26 to order. The agenda today is to approve minutes of prior meetings and then to work 3 bills. Why don't we start with the motion to approve the minutes?
Thank you, Mr. Chair. I would motion to approve the minutes, and do we have the exact dates?
Teresa, do you have those dates, or I don't know that it's necessary. We're talking about all the minutes for all the meetings we've held this session.
For the meetings we've held this session.
I'll second. Go ahead.
Any discussion? Seeing none, all in favor say aye.
Aye.
Opposed, nay. Passed. All right. Next, we move on into the working 3 bills. Senate Bill 487, which the short version of that is the offender registration bill. Senate Bill 459, which is the prisoner review bill, and the Senate Bill 374, which is the competency bill. We'll start with the offender registration bill. Are there any amendments?
I have an amendment. Yes, I have an amendment.
Would pass that out. Here, okay, I have one. I have all of them, so. Okay, I'm going to ask Jason, the reviser, to first of all kind of give us a brief on the bill, the underlying bill, and then after that, give us a brief on the amendment.
All right. Thank you, Mr. Chairman. The underlying bill concerns the Offender Registration Act. It would establish a new registration system that's used by law enforcement to then relay information to the KBI. It would also deal with notice to appear for non-payment of fees, and it would eventually, once the new system is in place, allow offenders to register just at one point of registration where they live rather than where they work or attend school as is required under current law. Do you want to see if there are any questions about the underlying bill?
Yeah, why don't we ask about that first? Questions on the underlying bill for the reviser? Seeing none, why don't you go on and tell us about the amendment?
All right, so Mr. Chairman, the amendment that has been handed out, the amendment to the title tells you the biggest thing that this would do. It would provide for a petition to determine that an offender is indigent. And that new section 3 is on page, the second page of the balloon, page 3 of the PDF that it came from. Essentially, it just creates a simple petition system where the offender would petition the district court for a finding that they are indigent for the purposes of KSA 224905. That is the offender registration statute later in the bill that requires payment of certain fees. There will be no fee for this petition, so it is free to file. It would be accompanied by an affidavit, which would look like the affidavit used for determining whether docket fees are waived up in Chapter 60. So it's a pretty standard form that the offender would fill out, certifying, for example, their weekly income and signing it under penalty of perjury, just like you do if you're seeking waiver of docket fees or finding of indigency in other court proceedings. And the Judicial Council would have a form to accomplish this, which would be similar to what's already being used. The court could conduct a hearing if they so chose. They could also, without a hearing, deny the petition or grant the petition. And if they grant the petition, what they're finding is that for purposes of 224905, the person is indigent and the fees are waived, and they would enter that decision on the record. So that's what the new section would do. And then the amendment on page 11 of the PDF, I don't know what page of the actual printout it is, but if you flip to the top of the page, it'll say page 11 from the bill. Down at the bottom of the page, this is where the fees are found. Current law, you remit payment to the sheriff's office in the amount of $20 as part of your reporting, and you do it in each place you report. So it could be up to 3 places where you reside, maintain employment, or attend school. And the underlying bill added a technology fee of $10 to that registration, which means you could pay the technology fee as well in up to 3 places. So the amendment moves that fee into the end of the sentence so that you're paying the $20 fee just as you are in current law, but you're only paying the technology fee in the county where you reside. So you only pay one technology fee under the law as it will be until 2028. And then on and after July 1 of 2028, you only register and pay fees where you reside, so that problem sort of resolves itself at that point, and you'll pay the $20 and the technology fee in one location where you reside. Those are the 2 changes. Happy to answer questions.
Right, so what's the technology fee? How much is that?
Mr. Chairman, so it's established in Section 1 for 2 years to be $10, and then in Section 2 that further amends Section 1 in 2028, it can be reduced, but it cannot exceed $10.
Right, thank you for that. So we have an amendment. I think the way we'll do this, I'll take a motion and then we can, and a second, and then we can discuss it.
I would motion that we move my amendment.
Any discussion on the amendment? Yes, Representative Mosley.
Thank you, Mr. Chair. So this is for the reviser. Yeah, you're the reviser. I just want to make sure I'm understanding correctly. We've eliminated someone having to pay multiple technology fees with this amendment. That's correct. Oh, all right, perfect. Usually I'm more difficult than this, so I'm good. Thank you.
Right, Representative Smith.
Thank you, Mr. Chair. I'm sure it's in here, but can you tell me, indigent, how much can that person make before they're not indigent?
I think one of our researchers, or we'll get that. You need a few minutes? Okay. Yeah, it's set in the law. We'll find out and get back to you. And just to be clear, the reason that we needed to have the petition is because once the offender has been sentenced and served his or her time, he or she will still possibly need to register, and there's no court at that point that has jurisdiction over the case. That's why we had to add a petition possibility. I also understand from one of the conferees that Shawnee County's Sedgwick's doing that. So they're doing it without authority. We thought we would give them some authority to do what they're doing.
Thank you, Mr. Chair. To address your question about what that threshold is for indigents, it's defined in the Board of Indigents regulation that an eligible defendant is a person whose combined household income and liquid assets equal less than the most current federal poverty guidelines. And currently that number for a size an individual is $15,650. For a family of 4 is $32,150, for example.
Thank you.
All right. Seeing no further hands for discussion, we'll proceed to vote on the amendment. Would you close, please?
I'll close.
All in favor, say aye. Aye. All opposed, same, or nay. We're now on the bill as amended. We'll go ahead and discuss it, and then we'll take a motion. Yeah, Representative Barrett.
Thank you, Mr. Chair. Yeah, just to clarify, in the short term, there is this technology fee, but in the long term for the offender, if you look from their perspective, they're not going to have to always have these registration requirements in other counties when they're working in another county, maybe going to college in a different county. So it's not just beneficial to law enforcement to hold them accountable, but it's also good for the offender if they're living in multiple jurisdictions once this is fully implemented. So I think both sides will win with this.
Right, the rationale, general rationale for the bill was to streamline the registration process, bring it in line with modern day technology, and I think it accomplishes that. And I do also like the amendments. It It reduces somewhat the fees that we're going to be charging these folks before the system gets up and running, and it ensures that there is some mechanism by which someone who's indigent can get the fee waived. Any further questions? Oh, right. Representative Mosley. Mhm.
I just want to say that one of my biggest concerns about this bill originally was the excess fees to individuals who were offenders, and just my concern about them being able to fully be integrated back into society. So I just want to say I appreciate my colleague for addressing that in an amendment, and I think as the bill stands, that's something that, because we should streamline it. I think that they said the system's been around since like I was probably 10 or 12, and I'm like in my 40s now, so I think it makes sense for us to get into the future. So thank you for fixing the bill, and I support it as it stands.
Representative Martinez.
I'm sure, thank you, Mr. Chair. I'm sure that this has been clarified, but I'm just to clarify myself. So in 2028, that's just one fee, well, the fee and then the technology fee, the registration fee, the technology fee, one place, right?
Right. Maybe. That is to say, it may even be better for the offender or registrant in that the technology fee may not be necessary at that point. Is that what you're understanding? It can come down.
Okay.
It may not be eliminated, but it can't go over the $10.
Okay. And then until then, they register wherever they go to school, wherever they live. Do they pay the technology fee?
Once.
Each place, just one place where they live? Okay, thank you.
Okay. Seeing no further discussion, I'll take a motion. I think we need a motion on the bill as amended.
I move that we pass out Senate Bill 487 as amended favorably.
Second by Representative Schlingensieben. Okay.
And I'll close.
All in favor, say aye. Aye. All opposed, nay. Motion passes. The next bill we're going to work is Senate Bill 459. That is the Prisoner Review Board. You can pass it out, and I'm sorry, yeah, I have an amendment to it, so I wanted to. This is, I think it's the exact same amendment language that I passed out on Thursday. There may have been some tweaks, but I don't, were there a few tweaks or no? Okay. Were those technical in nature? Well, we'll go through them in any event. I think you've seen the bulk of this amendment. But anyhow, we'll start with a briefing on the bill from the reviser.
All right. Thank you again, Mr. Chairman. So SB 459, the underlying bill concerns the Prisoner Review Board. You may recall that right now the board is 3 members. They are employees of the Department of Corrections, and they serve at the pleasure of the Secretary of Corrections. The point of the bill is to change the membership of the board. It would become 5 members. 3 would be appointed by the governor and have certain qualifications required by the statute. 2 would be appointed by the Attorney General and have requirements described in the statute. And all 5 would be subject to Senate confirmation. The other major change in the underlying bill is to require parole hearings for certain high-level offenders, so old felony level A and current off-grid and level 1, I believe, offenders. Those parole hearings have to have certain notice requirements and public comment sessions, and if those don't occur, then the parole hearings are delayed. So there's some special provisions related to those high-level offenders in the underlying bill.
think then we'll now take your briefing on the amendment.
All right, Mr. Chairman, as you mentioned, you handed out an early version of the balloon amendment last week. This is an updated version. Just at the top, I mean, I'll get into the details, but the two major changes from what you saw before are there is now a provision for how the members will be paid, and there are certain provisions that are delayed until July 1 rather than taking effect on publication in the register. So those are the two big changes from what you saw before, and I'll try to highlight that. First of all, secondly, the reason the amendment is so long is because there are a number of sections added to the bill, and every time you amend a section, you have to show the whole law. So all of those sections added there in the title are shown in full in the balloon, and that's why it's such a big balloon amendment. The base section 1 is unchanged from the current bill, so I just removed it from the balloon. It would be as it appears in the bill. So the real amendments start on page 13 of the bill, page 2 of the balloon. Well, actually, there's a new insert on page 1, and then there's more inserts down here on page 13. But that's the main thing here on page 13 on to page 14 is dealing with the membership. You'll see that under current law, established within the Department of Corrections is this board. That language is removed so that the Prisoner Review Board is just established. They are not under the Department of Corrections. They are not under the supervision of the Secretary of Corrections as they would be under the current bill or current law. They are just established and essentially independent. On and after July 1 of this year, the board will consist of the 5 members provided for in the bill. No changes there on page 14 to the underlying bill about the governor appointing or the attorney general appointing. The changes that happen down below, I should highlight the strike in lines 23 to 25 on page 14. That is the Senate amendment that said not more than 2 of the 5 members would be members of the same, from the same congressional district. That is removed in the amendment. As is the sort of underlying idea that no one could be from the same, no more than so many from the same political party. That is not put back in. So essentially, there's just no requirement about the 5 members being from any political party or any congressional district. That's just removed entirely. So I wanted to be sure that was noted. And then the provision I just mentioned that you didn't see on last week's amendment is there in the first large box on page 14. It would be new paragraph 5. Members of the board will receive services and an annual salary, receive for services and annual salary equal to 70% of a district judge's salary as determined by the statute in Chapter 75 that sets the statutory pay for all judges. And I'll leave it to the proponents to remind me what that number is, but it's 120 approximately. So that there is a specific number pinned to that, but it is tied to that other statutory determination. So it's well established what, you know, how that would be done.
If I might just, yeah, it's, I believe it's 120,000 today, but because it's tied to the state district court salary, it would go up commensurate with that. So over time it would, well, or down, but it would change potentially over time.
All right. Thank you, Mr. Chairman, for helping me out there. The other amendment there was in the balloon last week, but it's important to understand why it's added. So with the new member starting on July 1, the request was to have somebody fill in the gap from effective date of this bill. The current members will serve until July 1 of 2026. That's in the underlying bill, page 14, line 41 and 42. And so what's added right after that is prior to July 1, the governor and the attorney general will appoint their interim members who meet the requirements of the section, and they will serve on and after July 1 while they are awaiting confirmation. So they will be essentially able to serve without confirmation, and then they are still subject to confirmation right after that. So in theory, there is no gap. July 1, there's a changeover, and Senate confirmation will begin after that. So that's the provisions on page 13 and 14. The rest of the changes, I'll see if there are any that are of particular, there are a couple that we should probably focus on. A number of them are just sort of minor changes to reflect the independence of the board, and so that's why they're in here, but a couple of them are a little more important than that. So attachment A, which is labeled as page 1 of the attachments, it's at the end of the bill pages. Attachment A, page 1, section 1 is KSA 223709. So this would actually go at the beginning of the bill. On and after July 1, the chairperson and vice chairperson of the board will be designated as provided in the statute we were just talking about, where they're appointed. And those are actually designated by the governor and the attorney general. And so that's just a clarification of how those folks will be determined. And then the B1, except as provided further, would change the current law there about how the board can use panels of 2 members to do certain hearings, and they can grant parole with certain limitations with a majority vote of the board. So the new provision in B2 would make clear that for those inmates that have special hearing requirements or that have a higher level felony, grant of parole will require a unanimous vote of all board members. So those would be off-grid, Class A felons, which are pre-93 top-level felons, and then anyone convicted of a sexually violent crime as defined in the parole board statute that's also in the bill. So those levels of offenses would require a unanimous vote of all board members. So that would be a substantive change at the direction of the requester. Section 2, I'll just briefly mention, there's a report from the board. It's made clear that that's a separate report, not part of Department of Corrections report. Section 3 calls them other employees of the department, so we remove the word other and make some technical changes in that statute. Section 4 is about the Prisoner Review Board can authorize its members to conduct hearings on behalf of the board. And we added a cross-reference back to that section I was just talking about where certain votes require a unanimous vote, just to make sure that those actually work together. You couldn't get around that requirement with this provision, and they just needed to be made consistent. And then I think all of the ones in attachment B are just those technical things, changing Secretary of Corrections to Prisoner Review Board to clarify that they are an independent board. I think every one of them in attachment B is that way. And I'm noticing one change on page 11 of the attachments. So it has an 11 at the top of the page. This is in the Open Meetings Act. Currently, the Prisoner Review Board, when conducting their hearings in a correctional institution, do not have to comply with the Open Meetings Act. Partially, that's for safety and access reasons. Is the policy behind it, I'm guessing. And there's just a piece added there to make clear that except that those hearings shall comply with the public comment requirements of the parole statutes. So they could do that in any way. It just means that they have to make sure they also comply with those public comment requirements I mentioned at the beginning of the brief. Then I believe the rest of the changes, yeah, there's only one statute in attachment C, and it just adds the Prisoner Review Board next to the Secretary of Corrections. So a minor change to reflect the independence of the board and not really anything else of substance in there. So hopefully that narrows it down to kind of the big issues. I'll be happy to answer questions if you need me to.
Thank you, Jason, and really thank you for all the hard work you put into this. It was, it took quite a lot of brain power, which you have, and effort, and so we appreciate that. Questions now for the reviser, Representative Schlingensieben.
Thank you, Mr. Chairman. So the bill basically is taking us back to pre-2012. Is that correct? And just refresh my memory because I wasn't here then, or add some memory or whatever. Inform me as why the change was made to the current situation and why we're going back, just to be clear about that.
Mr. Chairman, as your nonpartisan staffer, I'm not sure I can really explain the policy. I can tell you that from a statutory standpoint, it was because the governor at the time did an executive reorganization order that moved the board under the Secretary of Corrections, and then there was a trailer bill in 2012 that effectuated that in the statutes. So there was a policy discussion going on that I'll stay away from, but statutorily, it was due to an ERO.
Representative Carmichael, I know you have quite a history here, and if you could be as nonpartisan as possible, could you please describe what we were doing before and after?
Well, Mr. Chair, my history with the parole board goes back to about 1979, but those matters are now expunged. No. Yeah, to put it in a delicate way, Governor Brownback was concerned that the board as then constituted included some political appointees that I guess he had less than full confidence in. We serve with one of those appointees today. And so the governor decided to move these things in-house at the Department of Corrections in simplistic terms. And I think what we're doing today is probably undoing quite a bit of that because of the difficulties that we've seen have now arisen when DOC, I believe 3 DOC employees are making the decision. And so I certainly support this idea.
Thank you for that. So we're now, I don't think I moved my amendment, did I? Okay, I'm going to move my amendment. I'll take a second, and then we can discuss it. Okay. So are there any issues, or should I say questions, discussion points on the amendment? Representative Carmichael.
Thank you, Mr. Chair. I think this has been remedied now, and I may be incorrect, but directing principally toward Mr. Thompson. When I was reviewing the draft of the balloon over the weekend, I somehow got the impression that it was going to require a unanimous vote on what I thought were all parole decisions, but it looks to me like this, what we have in front of us, provides for a majority vote, except in those instances. And I'm not sure if it's majority. It may be that just the hearing panel can take that action. Can you just make sure I'm clear on what we've done, and we'll leave the why to others.
So, Mr. Chairman, one of the many things that I talked about in there, so I know there was a lot. This provision is attachment A, page 1 of the attachments. It's in KSA 22-3709. So current law there is subsection, it's labeled as B1 in the balloon, but that's the chairperson, and this would continue. The chairperson may designate panels consisting of 2 members of the board, which shall have the full authority and power of the board to order denial, grant, or revocation of an inmate's parole or conditional release, or for post-93 crimes, granting parole for off-grid crimes, or revocation of post-release supervision, or revoking an inmate's conditional release upon hearing by 1 or more members of the panel and by a majority vote of the board. So that's a really convoluted sentence, but so with the exception that I'm going to talk about in a second, they can use 2 members to do full powers for pre-93 inmates, and for post-93 offenses, they can use 1 member to do certain hearings, but then require a majority vote of the board to carry out that hearing officer's recommendation. That's how I understand that current law to be working, and that would be maintained. What's added then is for inmates convicted of one of those 3 levels of offenses, granting parole will require unanimous vote of all the members. And those are off-grid, Class A, and sexually violent crimes. Hopefully that helps.
It appears that someone presumed my concerns, and my appreciation to whomever it was who provided for that, and I think that resolves my concerns in that regard. Thank you.
Representative Smith.
Thank you, Mr. Chair. Jason, on the way they picked the board, did you say the Attorney General and the Governor would work together to pick three, or would they have their own individual picks? I was kind of thinking they work together to pick three of them.
Mr. Chairman, so this is part of the underlying bill, and it's also in the balloon. It's on page 14 of the bill. There are 3 members appointed by the governor and 2 members appointed by the Attorney General. So they don't have to necessarily work together. They would have had to work together on the residency of those members to avoid having more than one in a congressional district under the bill as it came to you. But the bill as amended would remove that requirement. So the 5 could be appointed no matter which congressional district they came from. So.
All right, so I don't see any other hands, and we will proceed. I close on my amendment. All those in favor say aye. Aye. All those opposed, nay. Motion passes. We're now on the underlying bill with the amendment. Are there any questions, discussion points? Yeah, I guess, we, as a committee, had a lengthy hearing, and we've discussed this and talked about it with the reviser quite a lot. A lot of work went into the amendment, and I think this is a good improvement on what the Senate sent us. Not that what they sent us was bad, but I think this makes it better, and so I close and move my amendment, the bill as amended. Second by Representative Schlingensieben, ranking. All those in favor say aye. Aye. All those opposed? Motion passes. We will. And Schlingensieben as well as Carmichael, record those votes, please. Moving right along, this could be, should be, will be the last vote, the last bill that we consider this session. It's Senate Bill number 374. It has to do with circumstances where the defendant is deemed incompetent for purposes of standing trial, and if that continues for some period of time, at some point the court declares them subject to essentially civil confinement, and there's some concern expressed because current law in some of those instances simply allows the defendant who's been charged but hasn't stood trial, and in some cases has been charged with very serious offenses, to simply, if you would, walk away and not be subject to confinement. So this bill, as I understand it, seeks to kind of close that loop. Do we have an amendment?
Thank you, Mr. Chair. I do have an amendment.
I said the loop, I should mean the loophole. I'll take one. Make sure I got the right one. All right, Jason, one last time, would you give us a bill brief, and then we'll have questions, if any, on the bill, underlying bill, and then ask you to give us a briefing on the amendment.
All right, thanks again, Mr. Chairman. So as you explained, the underlying bill is about, in the criminal procedure code, when someone is found not competent to stand trial. The bill would require, if that person is being considered for release from treatment after evaluation, or not being admitted for treatment after evaluation, that for certain high-level offenses, there would be a process for further consideration of evaluation and treatment of those defendants. There would be certain requirements for the petition, the written reports, and there would also be some special provisions for medication of these offenders that have a high-level charge. And finally, the bill has kind of a clarification of how the civil commitment statutes in Chapter 59 and the criminal procedure incompetency statutes work together. That's the amendment in the final section of the bill, is just try to clarify how those two processes are supposed to work together.
Any questions on the underlying bill? Purpose, general purpose or discussion? Seeing none? That's right, yeah. Now, if you would explain what the amendment seeks to do.
All right, thank you, Mr. Chairman, again. So the amendment at the bottom of page 1 onto the top of page 2 is more, I won't call it technical cleanup because it may have some meaning to it, but it is to try to make that provision make more sense, because the more we read it, there seemed to be an error in the underlying language that we started to fix by fixing words and never quite got it right. The understanding of the intent is that for a defendant charged with a felony, the default is that there will be inpatient evaluation and treatment, unless there is a screening criteria from the state security hospital that that defendant meets, and then it could be ordered to be on an outpatient basis. That's our understanding and the proponent's understanding of how this language is supposed to work, so we redrafted it to make that more clear, not intending a substantive change, but intending to clean up the language because it used terms like commitment, where commitment is a totally separate thing under this proceeding, not evaluation and treatment. And it had some typos in the underlying law, just incorrect words. So it was not well drafted, unfortunately. So we're trying to fix that. The other amendment further back, where is that first one? Page 9. And you'll see this language a couple of times. The chair, I believe, pointed out when we were looking at these provisions about where the prosecutor may appear in these commitment proceedings, evaluation, treatment, commitment proceedings, that in one place it talks about making argument to the court, but in this place it did not. So the first change is to make that consistent language so that the prosecuting attorney can appear, call or inquire of witnesses, and offer argument to the court. In addition, the defendant's attorney in the pending criminal proceeding is added to have the same ability to appear, make argument, inquire of witnesses. So essentially giving a chair at the table to the defense counsel for the criminal proceeding as well as the prosecutor. And in the underlying bill, it's only the prosecutor, as you may recall. Then on page 10, that is the language that we just borrowed from. The prosecutor has the right to appear and do those things we talked about, and then the defense attorney is added to the same provision. We noticed in lines 12, 18, and 19, there was one reference to the Secretary for Aging, two references to the Secretary for Aging and Disability Services that was removed in other places, and it should have been removed here as well. So we fixed those two mistakes and also fixed a cross-reference error there in line 12. There's an E that should have been a D because of the renumbering on this, or redesignating on the Senate side. We just didn't catch it until now. So those are a little bit of cleanup. And then finally, page 12, I'll highlight the big box first. Defendant's attorney is given a seat at the table, just like in the other places. And then the smaller, but maybe of more importance to you, change, page 12, line 1, preponderance of the evidence is changed to clear and convincing evidence, which a lot of people thought had been done on the Senate side, but had not. And this would do it here on page 12.
So, yeah, I mean, these amendments largely reflect comments by opponents or neutrals. I'm not sure which we appreciated. Basically giving defense counsel equal rights to appear on behalf of the defendant in these evaluation proceedings. And then the error or the need to change preponderance of the evidence to clear and convincing evidence, which everybody agreed should be done, but somehow didn't get made, so we made that change. Are there any questions? Representative Neely.
I just want to make sure that there isn't a consequence in here that we've heard how long it can take for them to get their evaluations sometimes. You know, I mean, we've heard, what, a year and a half sometimes. That if we're asking for them to additional, is that going to postpone the ability for trial, or is it going to make them on the street longer if they're doing outpatient before they seek trial?
I'm sorry, so I know there's a big problem with delay, and your question is whether this makes it worse?
Yeah.
And how might it do that?
Well, when it's on where it says, Nearing, that they will, if they are being evaluated and they're more serious crimes, that they seek more evaluation, is that the way I'm reading it?
Right. I think that the delay that is a problem, although we can't fix it with this bill, is that there's a delay in getting them into the evaluation process.
Right, but if they're on because in the amendment, I think it said something about maybe order to be conducted as an outpatient basis. So would they be out longer if they're seeking more evaluation before trial?
I don't read the bill as, I mean, there's a possibility of doing it on an outpatient basis, but I don't think that should delay things.
Okay.
Maybe I'm missing something. If someone else wants to, Representative Barrett may be able to give you a better response than I was.
Thank you, Mr. Chair. And thank you for the question. I think, and the revisor can correct me, that's really the process that's already going on now, where we were just clarifying that, is my understanding, unless I'm thinking of a different section.
Representative and Mr. Chairman, so the process at the bottom of page 1 onto page 2, yes, is attempted to just be a clarification. So if you're charged with a felony, you're generally going to be evaluating on an inpatient basis, but there are screening criteria that might get you to do that on an outpatient basis. And again, that's current law that's basically operating. I was trying to follow when proceedings have already been commenced and you're considering whether to release someone versus further evaluating them. That might be what you were getting at, I think. And I don't know if I have a good answer other than the policy choice you're asked to make is that these defendants have committed an offense, and rather than releasing them or not committing them, there's going to be further findings with looking at the totality of the evidence and clear and convincing evidence standard, and deciding that they should be essentially kept in the civil commitment process rather than released. And I don't know what that does exactly on the rest of the process, though.
I guess, yeah, so that would clearly, it would extend the process in that sense. The alternative in those circumstances that the offender, a serious offender, would be released and go on his way. Representative Carmichael.
Thank you, Mr. Chair. I do appreciate that this amendment is a substantial attempt to improve some of the concerns, at least that I had with the bill, and a number of them have apparently been remedied. I also am sorry to say that I haven't had a chance to fly spec this amendment. And this is an important decision, so I may well be a no today, not necessarily because I'll be a no on the floor, but I want to study it more. And I also hope that those folks who are known as stakeholders, if after they've reviewed this amendment, if they have concerns with what I expect we're about to do, I certainly want to hear from them before this bill goes to the floor, because if there's something we missed, I want to be in a position to perhaps bring it to people's attention. That being said, I think the reviser might be the best person to help me with this. I can think of 3 circumstances at least where competency, if you will, enters into the process. First, there's competency to form the mens rea, or the intention to commit the crime, because some people don't realize the consequences of their acts. Under at least one of the standards, they have to know that it was wrong. There's a number of things in there that allow someone to, quote unquote, plead insanity. And I don't think this bill is that. Then we reach the circumstance where we have a criminal defendant, be it misdemeanor or felony, who is awaiting trial, and they don't have the mental competency to assist and participate in their defense. Doesn't necessarily mean that they were insane at the time they committed the act. It just means you can't try someone who is so out there that they can't participate in their defense, I think, as I understand it. Then we have a third standard, which is the general civil commitment concept. And I'm not an expert on it, but danger themselves or others is 2 words that kind of come to mind when I start thinking about that. Not everybody who was insane at the time they committed the offense is now not mentally competent. Maybe they've healed. Not everybody who can't assist in their defense necessarily is a danger to themselves or others. It may just be that they're out there somewhere and can't participate. And then third, we have the people who may not meet any of the standards about assisting in their defense. They can assist in their defense. People who were sane as can be on the day they committed the act, but who at some point in the process become mentally incompetent and can't take care of themselves and may constitute a risk to others. And I guess to put this into sort of a question, if I might inquire the reviser in general terms at least, what is the difference between the competency standard that needs to be present before you can try someone versus what level of competency is required to hold someone pending civil commitment? How does that work? Just because I can't help in my defense doesn't necessarily mean I'm dangerous to others and need to be committed. Conversely, just because I can help in my defense doesn't mean that I'm not a danger to other people too. Can you help me at all just conceptually understanding how the various standards work under this amendment? Long story, short question.
Mr. Chairman, Representative, that's an excellent question and a difficult one, and you had a lot of testimony that attempted to answer that from some folks who work in this area. So I'm hoping I don't say anything that's too far off, but generally speaking, your 3 items were correct. I mean, there is one set of standards for mens rea, or culpable mental state, as it's called in our criminal code. That's not what we're talking about necessarily in this bill. Then there's the incompetent to stand trial part. That's what we're talking about in the Chapter 22 statutes that are in this bill. And you're correct that the 2 items under that are you're either unable to understand the nature and purpose of the proceedings against you, or you're unable to make or assist in making your defense. So those are the 2 ways that you end up in this competency proceeding and you're found to be incompetent. And then as part of that, you're later evaluated and considered for potential to regain competency. That's one of the main goals of this Chapter 22 process is to help you regain competency through medication or treatment or otherwise so that you can stand trial. For others, if after 6 months you're not able to regain competency or establish competency, that's when the petition for civil commitment is filed. And that then brings in this other standard of, which is in the bill, but it's been removed, the section from Chapter 59 that defines what it means to be a mentally ill person subject to involuntary commitment. And it is one of the things you mentioned is likely to cause harm to self or others. That is one of them. But it's a person who lacks capacity to make an informed decision concerning treatment, which is different than some of the other things we talked about, is likely to cause harm to self or others, and whose diagnosis is not solely one of the mental disorders listed, such as substance abuse or intellectual disability or some sort of organic mental disorder. Those are all kind of laid out in the Care and Treatment Act. The wrinkle is the final section of the bill that says none of the Care and Treatment Act applies to a mentally ill person subject to involuntary commitment who is in custody on a criminal charge, except when you get the consent of the prosecuting attorney or the trial court. So in practice, that's happening now, and that's how these standards start getting applied. And then the bill adds a whole paragraph or subsection on the final page of the bill that just says, when you're over here in the civil proceeding, but you got there because of the criminal proceeding, there are new provisions that apply to you, especially if you're charged with one of these high-level offenses. So you kind of progress from one to the other potentially, or you stay in the criminal side trying to regain competency. And that's about the limitations of what I understand. So hopefully that gets to your question and gives you an idea of what we're talking about.
It's a great assistance. I'm not sure I'm competent to understand all of it. But I will try to regain my competency before the bill hits the floor. However, when we go to the third stage where we have someone who's not competent to stand trial, and then they go into this third category, if you will, I do appreciate my colleagues' concern that people could be on the street without a determination. If they meet the screening requirements of the state hospital, then they may be on the street before determination is made, I believe. Is that correct, or? Yeah, outpatient.
So, Mr.
Right.
Chairman, yeah, outpatient evaluation and treatment is one of the possibilities.
And hence, they may be out there for some months when some people think they need to be in jail. I understand that. But conversely, is there any limitation on how long someone can be held following the 6 months after a determination of incompetency to stand trial? Is there any limitation on how long this further commitment process can take? I mean, somewhere speedy trial is going to start getting involved in this and a number of other topics that cause me concern. And by the way, generally speedy trial is suspended during a period of someone's incompetency. But then once you start holding them afterwards, waiting for a determination, then if not statutory speedy trial, constitutional speedy trial, if it still exists, might be implicated.
So, Mr. Chairman, I think we heard a little bit of testimony from someone where they used the phrase restarting the clock. And so I don't want to be an advocate or say, anything pro or con. I don't have a position on this, but so you are required, if they have not attained competency within 6 months from the date of the commencement of their treatment, to file this involuntary commitment proceeding for that person. And that is for the speedy trial reasons, which are paused but are still constitutionally relevant. And that's just the way the Chapter 22 procedure is set up. There are time limits. But given delays in admission to evaluation and treatment, sometimes that extends for a long period of time. I think you heard testimony that there are some folks who are waiting for this for much longer than you might think if you just look at the statute. So I don't want to minimize that. I think the major change to the civil side that's made in the bill is to say if you end up in the civil commitment under Chapter 59 because of the Chapter 22, the criminal method, all of these new provisions on the back page are going to apply to you. So you're going to be presumed that you're likely to cause harm to self or others because of the offense that you're alleged to have committed, which makes you eligible to be detained under civil commitment, right? Or you're going to not be released without a special hearing and trying to determine whether you really are subject to involuntary commitment, essentially trying to make it so that these folks could be retained for longer on the civil side, which I presume is so as to not to violate any of those criminal constitutional protections you were talking about. So I think those are playing hand in hand here, attempting to hold these folks under the civil standard and thus requiring clear and convincing evidence and requiring these other items that have been added. But that I understand is the goal, is to hold them on the civil side. And right now, that's difficult to do because the standard for holding you on the civil side is not the same as the standard on the criminal side. And that's, I think, some of the confusion that I'm having, that you're having. And maybe that helped.
Mr. Chair, not a question, but a comment. First, I will try to study this better in context in the interim here. But also, I fear that we open the door here for an onslaught of habeas corpus actions, but we'll see how that turns out.
All right, any further questions? Representative Smith.
Thanks, Mr. Chair. I know this is different, but a high-level offense, and I know they have not been accused, but this morning, if they were accused, we would not let them out.
This morning, the bill that we,
Yes,
that was after the people had been actually convicted.
right. Yeah,
In these instances, the people have been charged, but because they aren't competent to understand what's happening to help assist with counsel, then we have to go through these other procedures.
And I do understand that
yeah.
it's different, but again, a high-level offense, they could be dangerous if they were out. So, thank you.
And that's really the loophole, as I said, we're trying to plug up. Any other questions? And I think we voted on the amendment, did we not, or not yet? No, we have to, okay. Do we have a motion? Where are we procedurally? Okay. Second, Representative Schlingensief, all in favor of the amendment, say aye. Aye. Opposed? Passes. Okay, we're now on the bill as amended. Any further discussion? Seeing none, all in, you need to make a motion on the bill as amended.
Yep, thank you, Mr. Chair. I do move that we pass out Senate Bill 374 as amended favorably for passage.
Second, Representative James. All in favor, say aye. Aye. All opposed? Passes. Okay, you want your, okay. With, note in the minutes, with reluctance, Representative Carmichael is a no. And he might change his mind by the time we get to the floor, maybe. Okay, committee, anything anybody wants to say before we adjourn? We did good work. I think the session was a good one. We did some good things, I hope, for the state. And today we got through 3 important bills, and thank you again for all that everybody's done to make this a successful Corrections and Juvenile Justice Committee for that year. So thank you. We're adjourned.